Honorable Member of Parliament of Rajya Sabha of BJD Odisha and advisor and mentor of Lex Mantra Legal and Business Advisory, the chief guest of this session, Shri Sujit Kumarji. Thank you, sir. Thank you very much for taking time out and joining us and accepting the invitation from our side to be the chief guest of this session. Before I invite him to address the gathering, I would like to request my technical team if they can please play a small film made on life and work of Shri Sujit Kumarji.
Shri Sujit Kumar is a Member of Parliament representing Odisha in the Rajya Sabha. He earlier served as senior policy planning positions with Government of Odisha, as the advisor in the rank of Chief Secretary to the Special Development Council of the Government of Odisha and Special Secretary of the Odisha State Planning Board. He is a trained engineer, lawyer and a policy maker. Shri Sujit Kumar completed Bachelor of Engineering from Veer Surendra Sai University of Technology and Bachelor of Laws from Sambalpur University. He started his career as a software engineer with Infosys Technologies Limited. Later, he shifted to the development sector and worked with the United Nations Development Programme, managing its ICT for Development project in Odisha, working to bring digital technology to the remote regions of the state. Shri Sujit Kumar has unique multidisciplinary experiences in the corporate, government and development sectors. He has travelled widely and spoken in numerous conferences and forums in India and abroad. He received the prestigious Youth Inspiration Award of 2017 for his innovative work as a policy maker, legal entrepreneur, and for his cutting-edge work at the interface of law, technology, development, and public policy. We warmly welcome Shri Sujit Kumar.
Thank you very much, sir. Once again, thank you very much for kindly accepting our invitation. Over to you, sir.
Thank you very much. Good evening, everyone. It's a great honor and privilege to be part of this valedictory ceremony of the first International Symposium on Law and Peace. And the theme can't be more apt, heralding peace and harmony through the lens of law and what's the way forward. I feel so humbled to be in this august presence of such luminaries from the legal field, from the academic field, and from different walks of life. Really, it's humbling for me to be part of this ceremony today. And I don't think I deserve to be the chief guest. Honestly, I have come to learn rather than to share my knowledge or wisdom. But nevertheless, let me compliment the great vision of great education of Dr. Karad, for setting up this MIT group of institutions, which has been doing such pioneering work, such commendable work in the field of education in the country. And his work is being very ably carried forward by, say, Rahul Karad, the managing trustee and executive president of this group of institutions. And I must particularly mention about the Valedictory Chapter Sansad, which I had the opportunity of interacting with a couple of students when they visited Delhi in March of this year. What a great bunch of students! What a great talent pool that you have cultivated, Mr. Karad. I must really commend you for that. Now, the topic which I have been assigned to speak today on is the administrative and political challenge in front of the Indian judiciary and some of the possible reforms that can be taken up by the judiciary. Again, this is so apt because only this week the Parliament debated the High Court and Supreme Court Judges Amendment Bill 2021, and close to 20 MPs spoke in the Rajya Sabha about this bill. There was nothing much in the bill per se. So the members of Parliament had a field day speaking on many aspects touching upon the judiciary and the relationship between the executive and the judiciary, or the legislature and the judiciary. So that has given me an opportunity to share some of the thoughts which I have culled from the parliamentary debate and parliamentary discussion. And cutting across party line, almost all the MPs expressed their concern about the dependency of cases, which is probably the biggest issue plaguing the Indian judiciary today. I mean, all of us know about the staggering statistics. I need not repeat that. And the worrisome aspect is that a bulk of this pendency is multi-year. You know, I'm told that over 77% of the 4.5 odd crore cases that are pending in different courts of India are more than a year old. And this number is even higher for the constitutional courts. For the High Court, it's 85%. Indeed, very staggering number and very, very worrisome. And this pendency is not only limited to the courts, it also extends to the tribunals. Right? A report by Alvarez and Marcel, which is a management consultancy, tells that the average age for cases to be disposed of in the tribunal, in the NCLT rather, is about 6 years old. And the legislation requires that NCLTs to dispose of cases within 270 days, right? So that's the gap that we are talking about. So I second my fellow colleagues in the parliament when they expressed their concern about this huge pendency of cases. Now, whether judiciary is responsible for it or the parliament is responsible for it or the executive is responsible for it now, I mean, this is debatable, but nevertheless, we have this massive concern and massive challenge that we have to worry about. World Bank doing business report, and in the last improved. But there is one area, so there are about 12 parameters or indicators in which various countries are ranked, and India had a very lowly rank of 130 odd until 2016-17. But in the last 2-3 years, the rank significantly improved, and now we are at a respectable 60 odd number. But one area where we are still at a staggeringly low number is in terms of enforcement of contract, where we are ranked 163 out of 190 countries, right? So this again goes to the basic issue of pendency of cases. And so again, the issue why investors are oftentimes reluctant to enforce their contracts or go for arbitration in India. So you have peculiar situation where two Indian entities decide to arbitrate in a third venue, whether it's Singapore or London or Paris. So I think this is something we need to really ponder about. The second issue which was raised in the House, in the Rajya Sabha, was regarding the vacancies. Again, not without attributing the reasons to any particular branch of government, I need to mention here that we have one of the lowest judges to ratio in the world. Our number is probably 20 something, right? But in the case of the US, it stands at 107. In the case of Canada, it stands at 75. In the case of Australia, it's 41. And the number in India is decreasing. So we have a decreasing trend of judges to population ratio. It should have been the other way. We have more than a third number of vacancies in the high courts, close to 400 plus. The high court judges vacancies there out of the 1100 odd sanctioned strength. So these are very, very staggering numbers, and the numbers are no better for the lower judiciary. The district courts, out of the 23,000 odd sanctioned strength of judges, we have only 17,000 plus number of judges. Again, not a very flattering number. Right? So these are something which really the judiciary and the parliament and the executive should really sit together and think about. The third aspect where I think we need to give some thought is regarding the utilization of funds. Now, I had read somewhere that the judiciary has been asking for more funds for better infrastructure, for better court structures, But recently I read an Indian Justice report which talks of the 2019 scenario in the country, and apparently, the judiciary is inefficient in utilization of funds. We have honorable judges here, and I think they would know it much better than I can express, that judiciary has not been able to, spend the funds allocated to it. So it's ironical probably that on the one hand, judiciary has not been able to spend the allocated funds allocated, sanctioned, and on the other hand, the judiciary is demanding more funds from the government. So I think this situation needs to be improved. And then the other big area where concern was raised was regarding the court infrastructure, which I briefly alluded to. Apparently, only 100 of the 665 surveyed district courts in the country had washrooms for women. It's unbelievable. Only 100 of the 665 odd district court washroom for women. Today, I had submitted a 0-hour question in the Rajya Sabha. Unfortunately, the House got disrupted regarding having washrooms in the national highways. So I had argued that there should be a washroom or a restroom, at least for women, every 50 kilometers. And then we have a scenario where our courts don't have washroom for women. I mean, this is something which really needs urgent attention. And I'm also told that more than 50%, 54% to be precise, court complexes do not have designated waiting areas. And we have witnesses from both the genders. We have witnesses who are, or we have the stakeholders who come to the court who are old, who are sick, who might be infirm. So if we don't provide them adequate waiting areas, if we don't provide them restrooms, washrooms, then what kind of justice can we think of providing? So these are some of the concerns which were raised. Concerns were also raised regarding the independence of judiciary. Without going to the specific appointments, I would share the concern of my fellow colleagues when they articulated that this is one of the fundamental political challenge before the court, that it needs to exclude itself from the influence of the executive. And here I'd like to quote Justice Krishna Iyer, the formidable Justice Iyer, and I quote him: during the career of judges, many carrots are held out to defect judicial performance from the path of rectitude. Judicial afternoons and evenings are sensitive phases, the incumbent being bothered about post-retirement prospects. The executive plays upon this weakness to bend the integrity or by the partiality of the elderly brother, unquote. This is Justice Krishna Iyer. In fact, even in the Constituent Assembly debates, legal luminaries like P.K. Sen, K.T. Shah, H.V. Kamath, K.S. Santanam, they spoke of the specific need of the Constitution to prohibit such employment. The Law Commission reports, numerous Law Commission reports have come down heavily on this practice, arguing that not only does it affect judicial independence, but also it erodes the dignity and the elevated status of the judicial office. And probably it's also an assault on the independence of judiciary, which is one of the core elements of the basic structure doctrine, as we all know. Collegium, fellow MP spoke of the collegium system, which unfortunately the Supreme Court struck down, the NJAC. So there was almost unanimous consensus in the House, cutting across party line, for review of the NJAC judgment. So with all due respect to the judiciary, I have my own personal views that probably it has the time has come for the judiciary or for the Supreme Court to constitute a larger bench to review the NJAC judgment, or for the Parliament to come up with a new piece of legislation to replace the NJAC Act, which was overturned by the Supreme Court. Judicial activism, many members spoke of judicial activism, or the judicial overreach or overstep, whatever phrase you might use, is not because the judiciary enjoys legislating, or the judiciary enjoys encroaching upon the turf of the Parliament. It has largely been so because the parliament has not done its job, which the constitution envisages. So, and particularly when the fundamental rights of the citizens of this country are being trampled, or when the fundamental rights of the citizens are at the risk of being trampled, then the Supreme Court or the constitutional courts have no option but to step in. Well, I think I was allotted 15 minutes, so I have probably spoken for 15 minutes. But I think this has been. Hello.
Yes, sir. You're audible, sir.
Okay. So yeah, but anyway, thank you very much for inviting me to share some of my thoughts. And incidentally, we discussed these issues in the floor of the House this week. So it was a great opportunity for me to share what my fellow MPs have deliberated upon, and has been a great learning experience speaking to luminaries who spoke before me. And again, I thank Professor Karad for the great platform that you are providing to hundreds of thousands of students across the country by providing quality and holistic education. Thank you.
Thank you very much indeed. Sir, you being the member of Parliament of Rajya Sabha, and as well as the legal and business from the field of legal and business advisory, you brought a completely different perspective into this particular conference, symposium, I would say. So thank you very much for taking time out and sharing your thoughts and views with us. It was indeed a pleasure listening to you. Thank you, sir. Thank you very much.